how to avoid the four-headed monster of elder law. Oh my. Oh, hey there, good folks. I am Patrick Kelleher. I am an elder law attorney, and I am here today, folks, to answer your question. One of our wonderful subscribers sent an email saying, hey, Patrick, how do I include real estate in my estate plan? Folks, get your pen and your notebook out and pull up your chair and get your favorite beverage. Mine happens to be matcha green tea, and it's pretty good, actually. But today's question from our subscriber, Patrick, how do I include real estate in your estate plan? And it's really straightforward, folks. Real estate, from my experience, makes up our clients typically the bulk of their estate or a good portion or lion's share of their gross estate, the family home, oftentimes second homes. And occasionally folks might have a third home, but not often. But the vast majority of our clients have a principal residence. We'll call it a family home, like my late great parents, and that was the family home they purchased 50 plus years ago before their departure. That's the principal residence. So important, folks. And I'm going to go back to our three-step treasure chest process, folks. You may recall in other videos. If you remember anything, and I told the good folks last evening when I was teaching our educational elder law workshop in the community, this guy here, the three-step treasure chest process, is the metaphorical sword and shield that slays that four-headed beast. This is the metaphorical four-headed beast, the four things you're looking to avoid like the plague. And this guy right here is the three-step process designed to avoid or slay these guys right here. So step one, you're going to design your trust with your experienced estate elder law attorney. It may look something like this guy right here when it's all said and done. And hopefully you're going to design it on a whiteboard or a smart board so you get all your dreams, goals, wishes, vision, aspiration up there. I call it your dream snapshot. And that's step one. You have the big red book, your trust-centered estate plan, your trust, your will, your big six disability planning. But it's not a magic red book, folks. This is step two. This is where the magic happens. This is where all the magic happens. This is where the rubber meets the road. Step two, trust funding. You have to get your treasures into your treasure chest. So take that real estate, folks, the family home, and you have your attorney retitle it, Bill and Mary as individuals, to Bill and Mary as trustees, or Bill and Mary's trusted most suitable child as a trustee of the Family Protection Trust, if it's a Medicaid trust, or if it's a revocable trust, you often should and could be the trustees of your revocable trust. Retitle that home and get it into your trust or your treasure chest and close the lid. Record it at the county registry of deeds office, folks, and that's how you protect it from the metaphorical four-headed monster, because sadly people die, but trusts do not. So folks, for real estate, you need to get it into your trust. You need to get into your treasure chest. Think of your trust like a metaphorical treasure chest. You need to retitle the home from your name as an individual to either your name as trustee or a trusted family member, preferably name as trustee of your trust, and then record that deed at the county registry of deeds office. Have your attorney do that work for you to make sure the T's are crossed and the I's are dotted. And that's what you do with your real estate, folks. And again, there may be other nuances to your particular situation. Do not mistake this or substitute this for legal advice. It's really extremely important that you work with your attorney in your jurisdiction, preferably an experienced estate elder law attorney in your state, your jurisdiction, because they will help you cross the T's and dot the I's, and you work together to do it right to slay that four-headed beast. So there you have it there, folks. And one last piece here. If you're creating an irrevocable Medicaid trust, write this down. Make sure it's a grantor trust, Grantor, because a grantor trust will also give you that, what they call the 1014 step up in tax basis. There you're going to get date of death value of that value of the property. For example, if you bought that property 50 years ago for $20,000, now it's worth $520,000 or more. You want your children, your beneficiaries in your trust to get that stepped up basis called date of death value, say 520. So if they sell it for 520, they're paying zero capital gains tax, right? I have another video on this, 4 reasons not to put your children's names on an asset. And one of the biggest detriments is if you put your children's name on that asset and they go to sell the property, oftentimes they're going to get bit hard by the second-headed monster, the tax man. They'll be paying unnecessarily capital gains tax. Capital gains tax here in the Commonwealth of Massachusetts is about 20%. 15% federal, 5% state. Would your children be happy writing that check for the CPA to pay the taxing authority? Absolutely not. So do it right. Work with your experienced elder law attorney. Folks, if you thought this video was helpful, please scroll down and subscribe, post a comment, a question, and share this with other folks that you care and love about. Also, if you want to learn more, go to Amazon, pick up my book, Elder Law Attorney Patrick Kelleher, How to Slay the Four-Headed Beast of Estate Planning and Elder Law, and check out our other videos as well. Be sure to subscribe, click that notification bell, because we release about 4 or 5 new educational videos per month. Folks, God bless. Thanks for being here today at elderlawcare.com.